This is the matter of State versus Eric Sweeney, docket 217-2023 CR 721. Attorneys Durand and Hinckley for the state, and attorneys Prusiner and Taggart-Hampton for Mr. Sweeney. This is scheduled for a plea hearing.
Thank you, Mr. Sweeney. If I could have you stand and raise your right hand, to the extent you're able. Do you swear the testimony you're to give in this proceeding is the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
Yes, sir.
Thank you. Put your hand down. Mr. Sweeney, I have here an acknowledgement waiver of rights form for the charges to which you'll be pleading this morning, the 3 counts of reckless second-degree murder and the count of falsifying physical evidence. This document appears to have been signed by you on August 13th, so 2 days ago. Is that correct?
Yes, sir.
And it indicates here that you've completed the 9th grade. Is that also correct?
Yes, sir.
Did you have an adequate opportunity to review the rights set forth in this form with your attorneys before you signed it?
Yes, sir.
Excellent. You can have a seat. I am going to ask for an offer of proof in support of the charges to which Mr. Sweeney will be pleading. Attorney Durand.
Yes, Your Honor.
Oh, yes. Yes, thank you.
Your Honor, just so that we also have the full, I guess, agreement between the parties on the record, if the court will allow me to lay out
Yeah,
that agreement.
absolutely.
Your Honor, the defendant in this matter has agreed to accept a guilty plea as follows. That would be to 3 counts of reckless second-degree murder under charge IDs 2348002. I believe there should be a C after that one. 2348003C and 2348004C. Those are with respect to the murders of Kassandra, Benjamin, and Mason Sweeney. The defendant has also agreed to plead guilty to falsifying physical evidence under charge 21361113C. The defendant agrees that as to charge ID numbers 2348003 and 4C, the charges related to the murders of Benjamin and Mason Sweeney. The state has met its burden as to RSA 651-6-1P, in that both victims were children under the age of 13, specifically Benjamin Sweeney being 4 years old at the time he was killed, and Mason Sweeney being 23 months old when he was killed. The defendant agrees through this agreement, Your Honor, that he will have no contact with any members of the Kassandra Southwick Sweeney's family, including Kristen Southwick, Terrence Southwick, Katrina Southwick Turnbull, and any other family members. He should also have no contact with Sean Sweeney. In terms of other members of the Sweeney family, Your Honor, given the relationship between everyone, he should not have any unsolicited contact with any member of the Sweeney family other than his mother, Heidi Sweeney, with whom he's had contact. There is no agreement in this plea as to sentencing. However, the parties agree that any sentence should include the following conditions. 1, that the defendant shall not profit in any manner for his role in committing these offenses, nor may he assign his rights to any monetary profit or financial benefit to another person. Specifically, he may not accept any payment, enter into any contract, or sell any rights related to any book, film, television show, radio show, website, podcast, or any other writing, recording, broadcast, or internet posting relating to the murders of Kassandra, Benjamin, and Mason Sweeney. The defendant will pay restitution, including funeral costs and associated mental health costs. The amount of restitution as provided to defense at this time is $29,290.88, payable to victims' compensation. Your Honor, as part of this disposition and pursuant to the defendant's plea, following sentencing in this matter, the state will enter a null pros to the indicted first-degree murder charges under charges 213-6110C, 213-6111C, and 213-6112C. And those are the terms of the agreement as it stands.
Thank you.
Your Honor,
And let me just ask, Attorney Prusiner, are those, as you understand, and I understand this is going to be a naked plea, meaning that no one has agreed to what either the defense or the state are going to argue for at the sentencing hearing on October 3rd. But with regards to those terms, other than the length of time and other provisions, are those, does Does that accurately state the parties' understanding and agreement with regards to the resolution of these charges?
Yes, it does, Your Honor, and we're in agreement with that.
Attorney Duran.
Your Honor, with respect to these charges, had the case proceeded to trial, the state would have relied on the following evidence to prove that the defendant is guilty beyond a reasonable doubt of the crimes to which he is pleading. Because, however, this is a bifurcated plea and sentencing hearing, the state may rely on additional facts of guilt and other evidence during the sentencing phase. In August of 2022, Sean and Kassandra Sweeney were...
To be clear, bifurcated, you mean we're going to do the plea today
And
and the sentencing
sentencing a
hearing
different day.
another day. Just
That's
want to be
correct.
clear about our language. No,
That's
absolutely.
correct, Your Honor.
Please go ahead.
In August of 2022, Sean and Kassandra Sweeney were living at 56 Weathersfield Drive in Northfield, New Hampshire. They lived at that house with their two young sons, Benjamin, aged 4, and Mason, 23 months old, and with the defendant, Eric Sweeney, who was then 16 years old. Sean and Kassandra were Eric Sweeney's guardians and had been since June of 2019. The family also had a black Labrador retriever named Daisy and a golden retriever named Moose. Evidence presented at trial would have shown that police were called to 56 Weathersfield Drive on June 6 of 2022 for an incident where the defendant left the house without permission, taking the family car. Police were also called on July 22nd of 2022 when the family reported, among other things, that the defendant was making some strange statements. On August the 3rd of 2022, at approximately 11:21 in the morning, then 25-year-old Sean Sweeney called 911 and asked that police and an ambulance be sent to his home at 56 Weathersfield Drive. When he was asked what had happened, Sean stated, "I don't know. My brother just called me from my wife's phone and said somebody broke in and killed them all." Sean told the operator to tell officers that he had two dogs, specifically that the black dog, Daisy, would not be friendly with strangers. Consistent with his statements during that 911 call, Sean would have testified at trial that Daisy would have barked and been aggressive towards any strangers that appeared at their home. Sean's brother was later identified as Eric Sweeney. At trial, witnesses would have identified Eric Sweeney as the defendant who's seated to my right at trial table wearing a white shirt and a tie. Officers with the Northfield Police Department responded to the 911 call. They arrived at 56 Weathersfield Drive at approximately 11:32 in the morning. At the top of the driveway, officers observed a large truck, traffic cones, and two workers from the Asplund Tree Service. The tree workers, Your Honor, had arrived on Weathersfield Drive at approximately 8:51 on the morning of August 3rd. If called to testify at trial, they would have said that they parked their vehicle on the street of Weathersfield Drive and blocked the driveway of 56 Weathersfield Drive with traffic cones because they were cutting trees on the edge of the driveway. While they were working, a white male, who they would describe as approximately 20 years old, average build, with short brown hair, wearing a baseball cap, drove to the top of the driveway from the house at 56 Weathersfield Drive to the street in a silver Ford F-150 truck. He did not ask for help. He did not speak to either of the workers. The workers moved the traffic cones so that he could drive away from the home. The workers would have testified that the Ford F-150 left that driveway approximately 30 minutes before police arrived on scene. Officers, when they arrived, moved from the truck down the driveway to the house. They found that there were no vehicles in the driveway. They knocked on the front door and received no response. Sergeant Holly Harris looked through windows that were situated near the front door of the home and was able to see a child and an adult female lying motionless in a pool of blood on the floor in the area of the dining room. Upon entering the home, officers found that the child and the adult female were each deceased, and each had suffered a single gunshot wound to the head. The child was later identified as 23-month-old Mason, and the adult female was identified as 25-year-old Kassandra Sweeney. As officers searched the home, a second child, later identified as 4-year-old Benjamin, was located on the floor in the kitchen, just steps away. Benjamin was also deceased, and he had suffered a single gunshot wound to the head. Benjamin was wearing a dinosaur costume with a hood on it. The hood of the costume was on his head, covering his face, and it had a hole in it consistent with a bullet entry. Your Honor, there are 5 exhibits that we've agreed are in full. I direct the court to State's Exhibit number 1. This image is an in-life photograph showing all 3 victims. And during the course of the trial, witnesses would have identified this as an in-life image of Kassandra with Benjamin and Mason standing on the front porch of their home. In the area of the victims' bodies inside of the house, officers saw several .40 caliber cartridge casings. They conducted a limited search of the home to determine if anyone else was inside, and they found no one. Investigators from New Hampshire State Police later escorted an assistant medical examiner into the scene to view the victims while officers were waiting for a warrant to search. At the time that they entered with the medical examiner, investigators observed in plain view a bath towel that was located on top of a trash can in the kitchen, close to where Benjamin was located. The towel was wrapped around several additional items, including a black handgun holster and some clothing. Later examination of these items showed that the clothing consisted of a t-shirt, shorts, and a washcloth. At trial, Sean Sweeney would have testified that the clothing was consistent with what the defendant wore to bed. While investigators were on scene, Sean Sweeney arrived at the top of the driveway, driving his oil truck. He was immediately followed by the defendant, who was driving Kassandra Sweeney's Ford F-150 truck. Sean took possession of the Ford F-150 at the top of the driveway and drove it down into the front yard of the home, while the defendant remained at the top of the driveway because he did not want to go to the house. While Sean was speaking with officers, the defendant walked down the driveway, encountering officers. He placed an object on the surface of the driveway and then was detained. Recovered on the driveway where the defendant had placed it was an iPhone 12 Pro cellular phone in a glitter-style phone case. That iPhone 12 Pro would be identified as Kassandra Sweeney's cell phone. A tree worker who was still at the top of the driveway told officers that the silver Ford F-150 that came into the yard was the same vehicle that had left the house just 30 minutes earlier. The worker stated that the male who had left the house and then returned in the silver Ford F-150 truck was the person who officers had detained in the driveway, the defendant. Sean would have testified that he was at work when he received the call from the defendant, and that after receiving the call, he drove towards his house. When Sean arrived at an intersection near the house, the defendant was waiting there, inside of Kassandra's Ford F-150. The defendant then followed Sean to the house. Your Honor, the oil truck that Sean was driving was equipped with a GPS tracking system and with a dashboard camera. Review of both the GPS and the camera footage placed Sean at work and in Andover, New Hampshire when he called 911. Portions of his 911 call, his side actually, were captured on the camera footage, and it was recorded live as he was hearing from his brother what had happened. And as such, were that to be played at trial, the court would have heard all of his reactions to his brother's phone call. Your Honor, if called to testify, Sean would have described growing tension in this family because of the defendant's behaviors, to the point that the defendant was no longer listening to Sean and that they were barely speaking to one another. The situation had deteriorated to the extent that Sean had installed a lock on the door to the master bedroom in order to keep the defendant out of that room. But he didn't believe, and he would have testified, he didn't think that Kassandra locked the door. On investigation, officers found that the door to Sean and Kassandra's bedroom did in fact have a locking doorknob that required a key to enter the room. Sean Sweeney would have testified that he owned 2 handguns, a 9mm high point and a .40 caliber Taurus. He would have testified that both handguns were stored inside of a locked safe underneath the bed in the master bedroom. When in storage, the guns were kept unloaded inside of holsters with loaded magazines next to them inside of the same safe. The safe was unlocked by a key, and there were 2 keys for the safe. One hung just inside the closet of the master bedroom, and the other was located on the key ring of the Ford F-150 truck. Investigators went into the home with Sean's permission and found the key to the safe that was hanging inside of the master bedroom closet. They later located the second key on the key ring for the Ford F-150, which was inside the truck. Investigators removed the safe from underneath the bed and found it to be unlocked. Upon opening it, they found inside the 9mm high-point handgun and a loaded 9mm magazine. However, the .40 caliber Taurus handgun and its magazine were missing from the safe. Officers secured the 9mm high-point handgun and were able, through the course of the investigation, to identify the missing handgun as a Taurus PT 24/7 .40 caliber Smith & Wesson pistol with a serial number of SCM 77497. Your Honor, I direct the court to State's Exhibit number 2, which is an image of that Taurus .40 caliber handgun. Your Honor, this Taurus PT 24/7 is a semi-automatic pistol. In order for this weapon to be fired, testimony would have shown at trial that a person would have had to first load the magazine into this gun, then chamber around by pulling back the slide in order to make the weapon ready to fire. In order to fire this weapon, Your Honor, the court can see just above the handle a flat horizontal piece. Your Honor, that is a manual safety. And in order to fire this weapon, a person would have to first disengage the manual safety. And then in order to fire this gun, each shot would require a separate trigger pull. Sean Sweeney would have testified that his Taurus .40 caliber handgun would have been loaded with mismatched ammunition based on the last time he had fired it 2 years earlier. But he couldn't remember what type or what brand because he hadn't purchased it but had obtained it from a family member. Your Honor, this information about two types or mismatched ammunition would later found to be consistent with evidence at the scene. Sean was shown a photograph of the holster recovered from the kitchen, and he would have identified it in court as the one that normally held his .40 caliber Taurus handgun. He would have testified that the defendant was aware that there was a gun inside of the house, but Sean didn't believe that the defendant knew the exact location of where the gun was stored. Investigators then conducted a physical search of the residence at 56 Weathersfield Drive in order to document all evidence of this incident. During that search, investigators photographed the bodies of Kassandra, Benjamin, and Mason, and they observed whether there was any sign of forced entry or a home invasion or any signs of intruders. Investigators found no sign that there was a forced entry or a home invasion. There were no apparent signs that the home had been searched or ransacked, other than the Taurus handgun and Cassandra's cellular phone. There were no signs of any items of value missing from the home. Investigators observed several televisions, a computer, an iPad, and other items of value, and Kassandra was found to be wearing her diamond engagement ring and a diamond wedding band, among other pieces of jewelry. Your Honor, I would direct the court to State's Exhibit number 3, which is in evidence in this matter. Your Honor, this is an approximate diagram. It is not to scale, just so that that's clear on the record. But this is a diagram, State's Exhibit 3, showing the layout of the first floor of the home. The green arrows with initials in them show the court the approximate location of each victim, where they were located when officers arrived, with the arrow tips showing the direction of their heads. The yellow circle at the end of the kitchen island shows the approximate location where the towel and the gun holster were recovered. During the execution of the search warrant, several items were also recovered. Inside of the kitchen and dining area of the house, officers located and recovered 6 .40 caliber cartridge casings. One cartridge was in the kitchen, near the kitchen sink, approximately where the court can see the kitchen window in this diagram. 2 were by Benjamin's feet, and 3 cartridges were on the floor in the dining area. 3 of the cartridge casings were found to be silver .40 caliber Federal Smith & Wesson, while the remaining 3 were brass .40 caliber Winchester Smith & Wesson. Investigators observed a bullet defect in the basement door. In looking at State's Exhibit 3, the court can see a red X that shows that approximate location. Testimony at trial would have been that this bullet defect was located towards the bottom of the door, maybe about a foot from the floor, and that it consisted of a short trench in the door rather than a hole through the door. Investigators, consistent with that short trench in the door, recovered a single bullet from the kitchen floor between the door and Kassandra's body. Looking at State's Exhibit 3, the court can see a red oval that marks that approximate location near the X in Kassandra's location. Further, investigators observed 4 bullet defects in a wall that separated the kitchen from the living room and the front hallway. The court can see a series of 2 X's and an oval that mark that location. The oval that is there with those markings where those defects were actually marks a bullet defect in the baseboard where a bullet was recovered. The approximate location of that bullet again being marked with a red oval on the corner of that wall. It was recovered from the baseboard, and it was located immediately beneath red-brown staining suspected to be blood. From the living room, and from the long wall in the corner, Your Honor, of the living room, according to the diagram, investigators recovered several projectiles and metal fragments, which were consistent with bullets having traveled through the dining room wall into the living room and heading towards that corner wall where the family had a sofa at the time. Based on evidence recovered from the scene, it becomes apparent that Benjamin was shot once in the area of the kitchen, closer to the playroom, while Kassandra and Mason were shot near the dining table and the front hallway. The bullets all traveled in the same direction, from the kitchen and dining area towards the living room. And based on the locations of defects, as well as the walls in the house, the defendant would have had to move from the time that Benjamin was shot in order for him to be close to Mason and Kassandra, in order to shoot them, and for the bullets to cause defects in that back corner wall. Your Honor, once the defendant was detained, he was later interviewed by investigators. During that voluntary interview, which was audio and video recorded, he waived his Miranda rights with a Benoit juvenile waiver form. During his subsequent interview, the defendant told investigators, for a lot of it in the presence of Sean Sweeney, who had collapsed onto the floor while listening. He told investigators that he heard what he believed to be a home invasion at the residence. Among other things, in the defendant's recount of the events of that morning, he reported that Kassandra woke him up in the morning and he went up to the second floor to take a shower. He indicated that when he came downstairs, Kassandra said, "That was quick." He then told investigators that he went to his room in the basement, bringing the clothes he had slept in with him to place them in his dirty laundry. While he was in the basement, the defendant said he heard something break. He heard a deep male voice yelling, followed by multiple pops. The defendant told investigators that he waited in the basement until everything was silent and then went upstairs. At the time that he went upstairs, he saw Kassandra, Benjamin, and Mason on the floor in the kitchen with blood around them, but he didn't know whether they were alive or dead. He just thought they were hurt. The defendant denied seeing anyone other than his family in or near the house that day. He denied involvement with the homicide, and he denied knowing who had hurt his family members. He denied hearing the family dogs barking at any point during this home invasion incident, and he denied seeing them when he left the house. The defendant told investigators that he had seen a black leather gun holster on the kitchen counter, but there hadn't been anything else around it. He said he took Kassandra's cell phone and car keys to the silver truck and drove away from the location in the vehicle. He admitted to investigators that he saw the tree workers at the end of the driveway and did not seek any help. And he said that he saw another friend, a 17-year-old, standing in a driveway on Weathersfield Drive, but didn't ask him for any help. The defendant confirmed that he knew that there was at least one gun inside of the house and that it was kept in a safe. He denied knowing where the safe was or where the keys were located, and he denied going into the master bedroom, handling a gun or the safe or the keys at any time. Throughout this statement, the defendant denied shooting these victims. Your Honor, Weathersfield Drive is a dead-end street. There's only one access point to the road, which is at the intersection of Shaker Road, which heads towards where the Tilton Diner would be. Investigators canvassed the area of Shaker Road in order to identify whether there were any cameras in the neighborhood, and they actually located a home at the intersection of Wethersfield Drive and Shaker Road, which had a motion-activated Ring doorbell camera. That Ring doorbell camera captures the Wethersfield Drive directly at the intersection of Shaker Road and thereby records any vehicles or people who enter or exit the street. The Ring doorbell camera showed that the silver Ford F-150 left Wethersfield Drive beginning at approximately 11:01 that morning. The silver Ford F-150 did not immediately turn onto Shaker Road, but rather stopped at the intersection for approximately 2 minutes. While the defendant was stopped at that intersection inside of the silver Ford F-150, a gray hatchback vehicle stopped behind it and then drove around because he wasn't moving. No other vehicles were seen leaving Wethersfield Drive between 10:49 and 11:01 a.m. The driver of the gray hatchback would have been in court, and she would have testified that she stopped behind the silver Ford F-150 when she was leaving her street, and when that vehicle didn't move for several minutes, she drove around. As she passed the vehicle, she saw that the driver was a young white male with short hair who was looking down as though he was looking at a phone. The Ring doorbell camera from the investigation did not show any unknown individual or any unknown vehicle entering or leaving Wethersfield Drive. The footage from the Ring doorbell camera did also, however, capture Sean Sweeney driving into the neighborhood with his oil truck at 11:51 that morning, with the silver Ford F-150 driven by the defendant following immediately behind him. On August the 4th of 2022, autopsies were conducted on Kassandra, Benjamin, and Mason at the New Hampshire office of the Chief Medical Examiner. Chief Medical Examiner Dr. Jenny Duval found that each victim had suffered a single gunshot wound to the head. As to Kassandra, Dr. Duval would have testified that the bullet entered just above her right eyebrow. A bullet was recovered from her skull. Dr. Duval would have testified that her examination of Kassandra's injuries and body showed the presence of stippling, or burns in her skin from the gunpowder released by a gun, which would indicate that she was shot at an intermediate range, with the end of the gun being between 6 and 30 inches from her head. As to Mason, the bullet entered at the right front top of his head and exited behind his left ear. As to Benjamin, the bullet entered in the left front top of his head and exited behind his right ear. Dr. Duval later examined the hood of Benjamin's dinosaur costume, and she would have testified that she observed there particles that were consistent with stippling that would indicate that Benjamin was also shot at an intermediate range. As to each of the victims, Dr. Duval determined that the cause of death was a gunshot wound to the head and the manner of death was homicide. There was no evidence of any other injuries or trauma. On August the 5th of 2022, investigators conducted a search of the silver Ford F-150 and processed it for physical evidence. Some of the evidence included gunshot residue kits from the top and bottom of the steering wheel. That same day, the New Hampshire State Police Forensic Laboratory sent the GSR kits out to an independent forensic laboratory for testing. On August the 9th of 2022, investigators received the results of the forensic testing from both the defendant's hands and from the steering wheel of the silver Ford F-150. The testing confirmed the presence of GSR particles on the right and left hands of the defendant, with more material deposited on his right hand, and the defendant would be noted as being right-handed. Further, the presence of gunshot residue particles was confirmed to exist on the bottom portion of the steering wheel of the silver Ford F-150. Given the presence of GSR on the steering wheel of the silver Ford F-150, investigators conducted a brief follow-up interview of Sean. Sean Sweeney would have testified that he told investigators that he had purchased the silver Ford F-150 on June 12th of 2022, and that he hadn't fired his guns for almost 2 years. Under these circumstances, sources other than the defendant and the current incident of the GSR found on the steering wheel of the vehicle are extremely limited. Investigators completed a forensic download of Kassandra's cellular phone and Sean's cellular phone. The download allowed investigators to document a timeline of events, including a determination of the approximate time in which Benjamin, Mason, and Kassandra were killed. Investigators on that phone, Your Honor, saw numerous videos that were taken that morning and learned that Kassandra had sent several messages, including videos, to both Sean Sweeney and to her mother on the morning of August 3rd. Further, investigators found that location services were active on Kassandra's phone, and they were able to review GPS data locations as well as device events. The videos that investigators reviewed were created between 10:48:40 in the morning and 10:55:01. Through a review of those videos, investigators were able to observe Benjamin and Mason inside of 56 Weathersfield Drive. They were alive, and they were showing no signs of distress. Investigators could hear Kassandra talking to the boys. She was alive and showing no signs of distress. The videos demonstrated that the family was having a normal morning with the boys, playing and laughing with Kassandra while helping her to create video clips to send to their dad. There was no indication that any unknown person, intruder, or danger was inside of their home. At 10:48:40, which is the first video, Benjamin is wearing a dinosaur costume. He's got the hood down, not on his head. You can hear Mason laugh off of camera because one of the family dogs bites Benjamin's tail. At 10:48:42, Benjamin is still in his dinosaur costume and he's got the hood down. And he's talking about how he loves Mason. Mason can then be seen at the end of the video. He's wearing a yellow shirt and white pants that have trucks on them. Other videos show the boys playing, saying cheese, or saying hi dada to the camera, which were the messages that Kassandra was sending to Sean. At approximately 10:49 in the morning, Kassandra sent Sean a text message that said, "I hope these make you laugh," referring likely to the videos that she'd been sending him of their children. At approximately 10:52 in the morning, Kassandra recorded a 30-second video of the boys looking out a window in the playroom of the home. At that time, Mason is still wearing his yellow shirt and white pants, but Benjamin's no longer in the dinosaur costume, wearing blue shorts and a white shirt. The video shows again how relaxed the morning was even at 10:52, as the boys watched a groundhog out the window and interacted with Kassandra. Kassandra laughing as the boys described it as a hedgehog. At 10:53:23, just moments later, 2 videos were recorded showing the boys upstairs in what would have been identified as the master bedroom, or bathroom, I apologize. The state would ask the court to direct your attention to State's Exhibit 4, which is in evidence. This is the last images of both Benjamin and Mason. At this time, at 10:53:23, Benjamin is now back in his dinosaur costume. He's got the hood up over his head, shown here, as he appears at the time of his death. This image was taken approximately 6 minutes in the timeline before they were killed. At 10:55 a.m., there's another video that doesn't show the children. That video was recorded showing the front yard of the house. It shows Kassandra's Ford F-150 vehicle that was parked near the porch, and that would later be taken by the defendant. This video appears to have been taken looking out the window of the upstairs master bedroom, and Kassandra is narrating or talking about the condition of the front yard and how it didn't survive the winter. At least one of the boys can be heard in the background, but you don't see them. This is the last video that was recorded by Kassandra, 10:55 a.m., and she appears to have sent it to Sean moments later at 10:55:11. Between 10:57:30, so only 2 minutes later, and 10:58, Sean Sweeney would have testified that he sent 4 Snapchat chat messages to Kassandra's phone, and he would have testified that none of those messages appear to have been read. The phone's device event log shows that it was unlocked, picked up and unlocked at 10:58:10 that morning. And between 10:58 and 10:59, the phone began showing movement consistent with leaving the house or being in the yard. If called to testify, analyst Tracy Flaherty would have stated that at 10:59:30, she would clearly indicate that the device began to move away from the Sweeney residence and onto Weathersfield Drive. Based on this timeline, investigators believe that the defendant would have fired 6 shots from the Taurus handgun, with 3 of those shots striking Kassandra, Benjamin, and Mason, each one time, killing them at some point in the 4 minutes between 10:55:11 and 10:59:30 in the morning. At 10:59:33, the device was halfway between the house and the street. At 10:59:43, the device was on the street, starting towards Shaker Road. As indicated by the video at the Ring camera video at the corner of Shaker Road and Weathersfield Drive, the device also showed that the device was stopped at the intersection of Weathersfield Drive and Shaker Road, consistent with the video footage from 11:01 to 11:03 that morning. At 11:03:50, Google Maps was accessed and made in use, which provided even more detailed location information for the device, almost moment by moment. Between 11:03 and 11:10, the device traveled down Shaker Road to Route 140 and then directly onto Interstate I-93 South. At 11:10, the device was traveling and moving southbound on Interstate I-93. Almost 17 minutes after he left the house, at 11:16:46, and as the defendant was driving south on I-93 past exit 18, the defendant, for the first time, used Kassandra's cellular phone to make a phone call. He called Sean Sweeney. That call did not go through, likely given the fact that Sean Sweeney was in a poor service area at the time. I'd like to direct the court to State's Exhibit number 5. This is a map which documents not only the location of the phone, but certain actions in terms of sending messages or making phone calls. The court can see at the very top that first phone call at 11:16:46, which was an outgoing call to Sean's phone with no time on that call, indicating it did not go through. At 11:17:32, Kassandra Sweeney's phone, held by the defendant, sent a message over Snapchat to Sean Sweeney that said, "Help." At 11:17:43, he wrote, "It's Eric." The court will note that there's a red marking at 11:17:55 a.m. That location is consistent with where authorities would later find a handgun on I-93 southbound in the center median. On 11:18:08, the defendant, immediately after that location where that gun was discarded, the defendant sent his third Snapchat message, which just said, "Sean." At 11:19:17, that is the call that actually made it through to Sean Sweeney, where the defendant at exit 17, 3 exits from his home at Weathersfield Drive, almost 20 minutes after the murder or after he left the house at 56 Weathersfield Drive, he told Sean Sweeney that there was a home invasion at the house. Over the course of several days, Your Honor, investigators used GPS location data from the cellular phone and identified areas to search for that missing handgun. There were extensive searches conducted along the entire path of the defendant's travel. There were places where he was observed to have stopped for moments and waited for Sean, for instance, where investigators searched because of the length of time the vehicle was there. There were places where Wi-Fi had connected, and so investigators were searching in those locations as well. On August the 11th of 2022, Conservation Officer Kenneth St. Pierre and his canine unit from New Hampshire Fish and Game was participating in one of those directed searches, this time on southbound I-93, approximately 1 mile before exit 17. That is the location that's consistent with the red markings on State's Exhibit 5 and consistent with the location of Kassandra's phone on August 3rd, 2022 at 11:17 in the morning, in the midst of the defendant reaching out to contact Sean Sweeney. At that time, Officer St. Pierre and his canine unit located a black .40 caliber handgun and a magazine in the center median. These items were there consistent with having been thrown separately, so the magazine first, followed by the gun. from the driver's side window of a southbound vehicle. The handgun would later be identified as Sean's Taurus PT 24/7 .40 caliber Smith & Wesson pistol with a serial number of SCM 77497. On November the 8th of 2022, an analyst from the New Hampshire State Police Forensic Laboratory conducted an examination of the recovered Taurus .40 caliber handgun, and she compared the handgun to casings, projectiles, and fragments recovered from inside of the house at 56 Weathersfield Drive, as well as the projectile recovered from Kassandra during autopsy. If called to testify, Jill Terrio would have indicated that her examination found that the Taurus .40 caliber handgun belonging to Sean Sweeney and found on I-93 southbound had fired the 6 casings recovered in 56 Weathersfield Drive, as well as the bullet recovered from Kassandra at autopsy. She would state that some of the fragments were too small or too damaged to complete analysis, but her examination would also find that the Taurus had fired the 2 intact bullets recovered inside of 56 Weathersfield Drive, and that the state would argue that based on the locations where they were recovered, one in the kitchen next to the door and one in the living room just below suspected blood, that these are believed to be the bullets that passed through Benjamin and Mason's bodies, killing them. Or that is the case that the state would have presented at trial, and that is what the evidence would have shown.
Thank you. Attorney Prusiner, Attorney Taggart-Hampton, Mr. Sweeney, if you would stand. With regards to the elements of the offenses for which Mr. Sweeney would be, is going to be pleading this morning, is there any dispute based on the offer of proof that the state could meet those elements?
There is no dispute that the state could meet those elements, Your Honor.
Thank you. Mr. Sweeney, you understand you don't have to plead to these charges. Do you understand that?
Yes, sir.
Do you know how many people would serve on the jury if you were to have a jury trial?
12.
How many of those 12 would have to find you guilty beyond a reasonable doubt for you to be found guilty?
All of them.
That's correct. The state, and this as in all criminal cases, has the heavy burden to prove you guilty beyond a reasonable doubt. You don't have to prove your innocence. The state needs to prove you guilty. Do you understand that?
Yes, sir.
At a criminal trial, the state cannot force you to take the stand and testify against yourself. But if you want to, you would have the right to take the stand in your own defense and call witnesses on your own behalf. Do you understand that as well?
Yes, sir.
Do you understand that by pleading to these charges, you're waiving those rights?
Yes, sir.
Have you had an adequate opportunity to review the circumstances surrounding these charges and your decision to plead to them with your attorneys?
Yes, sir.
Are you satisfied with the work by both Attorney Prusiner and Attorney Taggart-Hampton on your behalf in this case?
Yes, sir.
And you understand that as part of this resolution, you're giving up the right to appeal decisions that I have made on motion to suppress. Do you understand that?
Yes, sir.
And have you discussed that with your counsel as well?
Yes, sir.
And other than the fact that there are some agreements that we talked about at the very beginning of this hearing, the sentencing hearing, which will take place in early October, I can sentence you to anything up to the maximum for these charges. Do you understand that?
Yes, sir.
And have you discussed that with your counsel?
Yes, sir.
Have you consumed any drugs or alcohol in the last 24 hours?
No, sir.
Are you doing any medically assisted treatment, Suboxone, methadone, anything like that?
No, sir.
And are you pleading guilty to each of these charges because you are in fact guilty of these charges?
Yes, sir.
Attorney Prusiner, Attorney Taggart-Hampton, are you both satisfied that Mr. Sweeney has made the decision to plead to these charges knowingly, voluntarily, and intelligently?
Yes, Your Honor.
Yes, Your Honor.
Thank you, Mr. Sweeney. I'll now take your pleas to these charges, and I'm going to start with charge ID 234-8002. This charge alleges that on or about August 3rd of 2022 at Northfield, that Mr. Sweeney did recklessly cause the death of Kassandra Sweeney under circumstances manifesting an extreme indifference to the value of human life by shooting her with a firearm. As to this charge of second-degree murder, how do you plead, Mr. Sweeney, guilty or not guilty?
Guilty.
Next, as to charge ID 234-8003, this indictment also charges the crime of second-degree murder, alleging that on or about August 3rd of 2022 at Northfield, that Mr. Sweeney did recklessly cause the death of Benjamin Sweeney, age 4, under circumstances manifesting an extreme indifference to the value of human life by shooting him with a firearm. As to this charge of second-degree murder, how do you plead, guilty or not guilty?
Guilty.
Next, as to charge ID 2348004, this indictment also alleges a crime of second-degree murder that on or about August 3rd of 2022 at Northfield, that Mr. Sweeney did recklessly cause the death of Mason Sweeney, age 23 months, under circumstances manifesting an extreme indifference to the value of human life by shooting him with a firearm. As to this charge of second-degree murder, how do you plead, guilty or not guilty?
Guilty.
Finally, as to charge ID 2136113, alleging the crime of falsifying physical evidence, as has been amended. This indictment alleges that on or about August 3rd of 2022 at Northfield, that Mr. Sweeney, knowing that an investigation was about to be instituted, did alter, destroy, conceal, or remove a thing, to wit, a Taurus .40 caliber handgun, with the purpose of impairing its availability in said investigation. As to this charge of falsifying physical evidence, how do you plead, guilty or not guilty?
Guilty.
Mr. Sweeney, having examined both you and your counsel regarding your decision to plead to these charges, I find with respect to each of them that you've done so knowingly, voluntarily, and intelligently, so I accept your pleas. We have talked about the scheduled sentencing hearing. I believe we have October 3rd set, and I think we have the whole day set aside for that sentencing hearing. I take it, since there's no bail in this case, that will just remain as previously set by the court.
Yes, Your Honor.
And is there anything more that we need to do this morning?
Not from our end, Your Honor.
Your Honor, just so we have it for the record, I'm sure the court anticipates it, but the state would anticipate filing a memorandum on sentencing approximately 10 days prior to sentencing.
That would be extremely helpful, and certainly, if that timing works for the defense as well, I would appreciate at least a week beforehand. It'd be very beneficial for me to have both sides' positions and their thoughts on sentencing in advance. I know we'll have the day hearing, but if you could submit sentencing memos in advance, that would be great. I don't know if does a 10-day time frame work.
Planning to do, if 7 days would be acceptable the previous Friday.
How about both sides do it on by that Friday, which is that'd be September 26th, by Friday, September 26th. Okay, great. Thank you all very much.
Thank you.
All rise, the court.